This video is presented by David's Hope in cooperation with Patricia Lester Jones and Mary Lou Bresnik. This video will probably speed up a little bit on the issue of mental health prisoners incarcerated, but the contents are self-explanatory, and I encourage you to look at each chapter separately when you get a chance, because it's very task specific and oriented as how the SMI, or severe mentally ill persons, are to be treated, diagnosed, and housed. This is a outline for an attempt to pass legislation to preserve life and stabilize those mentally ill within a prison setting, hereby called Tony's Law. And if you need more reference to this particular case, Channel 12 Phoenix has an entire episode and series on Tony Lester's suicide. Remember that the background and the reasons for the development of this proposal is to help those severely mentally ill inside prisons and those who are coming into the criminal justice system, as they are not receiving an adequate service to diagnose and treat their special needs. It is proposed that the state modify their laws to address the increased number of severely mentally ill persons incarcerated, and also mandate county jails and prisons to serve or provide services to these individuals, as the prison environment is indeed dangerous to those that are mentally ill, and placing mentally ill prisoners in prolonged segregation or non-treatment environment can only result in disastrous conduct. The broad definition includes other diagnosis, but the narrow definition includes a diagnosis of major depressive disorders, bipolar disorder, schizophrenia, or other psychotic disorders. It is also recommended you include alcohol and substance abuse, as it directly impacted their mental illness. We briefly covered the 8th Amendment for failure to provide mental health care can be held unconstitutional if it involves unnecessary and wanton infliction of pain, reflect correctional officials' deliberate indifference to serious medical needs of the prisoners. Substandard care, negligence, or even malpractice may constitute a violation of the 8th Amendment. We are recommending a proactive approach to managing the severely mentally ill by mandating law, setting all county jail mental health staff a complete psychological workup required, so that we can readily identify severely mentally ill as they come into the court system, and then recommend either before sentencing or after sentencing a judge's order that would in fact bind a legal obligation with probation terms and treatment terms outlined by the judge, and very well carried into the adult prison system if applicable. Cases where the inmate was not evaluated at the county jail should be done at the Phoenix Intake Center immediately within the next few days of their incarceration, as correctional officials must recognize the extreme challenges of working with and managing a large and growing population of mentally ill prisoners. It is up to the legislature to provide sufficient funding and logistics to address these issues, and we are recommending a 3-step program to help develop mental health treatment inside our adult prisons, both male and female, and that the judges on trial cases order and provide such orders to the Department of Corrections so that we can get the legal guidance for such purposes. Step 2 is the exclusion of prison segregation units by the definition of severely mentally ill that includes schizophrenia, delusional disorders, schizoaffective disorder, brief psychotic disorder, substance-induced psychotic disorder, psychotic disorder not specified, major depressive disorders, active suicide, or people who have engaged in recent serious suicide attempts should be excluded from segregation. People diagnosed with serious mental illness should also be kept out of segregation. And those that are substantially deteriorating, decomposing mentally or emotionally while in segregation should also be removed from segregation. This is a joint decision that is mainly clinical but will address security issues. Step 3 is the development of a mental health treatment center and a mental health multidisciplinary team to ensure a complete psychological follow-up of every SMI that's received, and to ensure that within 14 days of arrival in the adult prison system, they receive an adequate health care and medical examination that's quite lengthy but quite significant to their wellness and their ability to cope and function within the prison system. I strongly suggest that the mental health screen includes those items listed to make sure that the offender is adequately addressed in their needs, in their housing, and in their program assignments. Those that are severe and in current psychosis should be housed separate from the general population and observed and monitored, and when stabilized should be considered for reallocation to a general population setting with the proper assessment made by mental health clinical staff. Suicide prevention training is a must. It should be mandatory and should not be abbreviated. It should include at least 16 hours of special management training in self-harm, suicidal, watch issues, and should be applied to all staff with the responsibility for offender services and supervision, as well as the fact that a minimum of 16 hours for the SMI should be for all staff, not just correctional officers. The staff should learn and be familiar with identifying, understanding, responding, communicating, and refer based on observation and suicide activity within their span of control. It is important that the mortality review of SMI inmate is conducted in the manner as prescribed here in the video, but what is more important is the final draft or the final copy of the report should be sent to an external agency that has the power and the authority for oversight on all seriously mentally ill inmate injuries and attempted suicide as well as deaths. These reports should be maintained so that they're readily accessible to this oversight committee to be drafted by the legislative committee, and it is recommended to be an external oversight committee for the purpose of conducting an independent review of the report. Very important that this report be made accessible to an outside committee. SMI transfers within the Department of Corrections should be handled in a constructive manner that ensures communication between program administrators and facility administrators. This includes all transfers to other facilities. Please take the time to look at the long 13-page proposal for specifics, and I thank you.